morning, everybody, and welcome to our DFDL webinar on the tax and legal aspects of restructuring a business in Myanmar. My name is Jack Sheehan, and I'll be your moderator this morning. I'm a tax partner and head of the regional tax group at DFDL. For those of you who have not joined the DFDL webinar before, some basic housekeeping rules. Any questions you may have, please post them in the Q&A box. You'll see a small icon on the top of the screen, almost on the right-hand side. You'll see a Q&A box. Please enter your questions in there, and we will do our best to get through each of the questions this morning. All questions we will try to answer after our presenters have gone through the topics this morning. So any questions you may have, please do let us know. If we don't get back to you this morning, we will get back to you separately if we've got too many questions. So, and for those of you who haven't joined before, or it's the first time at a DFDL webinar, DFDL is a regional legal and tax firm, and we've offices right across Southeast Asia and in Bangladesh, and we've had an office in Myanmar for many years. Next slide, please. I'd like to introduce my colleagues. Nishant Choudhary is our country managing director in Myanmar and is a partner in the firm. Nishant has extensive underground experience in Myanmar, multiple different sectors, from not-for-profits right the way through to multinational companies. So Nishant has a lot of knowledge and experience to share with us this morning. We're also joined by Diberjohn Balinas. Diber is a tax director, also many years of experience on the ground, advising companies on tax issues in Myanmar and restructuring businesses and entering Myanmar and all the different interesting tax issues that can arise internationally and locally in Myanmar. So I'd like to thank my both colleagues for taking the time out this morning to put together this webinar. I would like to say before we go through it that when we talk about restructuring, we're not only talking about exit planning. Restructuring can take many different forms, from restructuring your shareholding to having a different holding company in place, to restructuring a loan, to restructuring many things. So this morning's seminar will take a holistic view of the different types of restructuring that we may see happening in Myanmar from both a legal and a tax perspective. So our agenda, as we move through the topics this morning, Nishant will give a general overview of what's the current situation in Myanmar, and we will look at some of what are the common types of restructuring that we do see. And Diber will be looking at some of the key tax issues when we look at restructuring businesses and some pitfalls that you need to be aware of. So there's many topics to get through. So I think on that note, I will hand you over to Nishant. Nishant.
Next slide, Vate. Vate, can you please move the slide? Thank you. Good morning, everybody. Thank you, Jack, for the kind introduction. Hello, Diber. Good to talk to you all. We all understand, and particularly people in Myanmar have a better understanding as to the current situation. How to set the tone of today's discussion, it is better to recapitulate as to what we are presently facing or what the situation on ground is. So as we all know, since 2021 Feb, there has been a state of emergency declared in the country. A body called State Administrative Council has been established, which sits or which presides over in hierarchy above the legislatures, executive and the judiciary of Myanmar. We understand that since the political situation in Myanmar, there has been international trade and or inbound strategical investments being affected, primarily for various factors, which differs from jurisdiction to jurisdiction. Importantly, 2022 has seen a more aggressive local economic distressed situation, if I can put it that way. Particularly, we have seen chat depreciate to a great extent. If we go by the CBM, Central Bank of Myanmar's reference rate, which is 1 USD is equal to 2100 Myanmar chat, though this does not give the clear picture of what the market sentiments are towards Myanmar chat, which is obviously at a much lower rate. Our understanding is that 1 USD is up to 3,300 MMK. Myanmar has opened up its ports since May 2022. We, at least till last week, were facing the 5th wave of COVID in the country, though probably the way, it wasn't that aggressive as we had seen in the 3rd wave, but we did see a bit of slowdown in Myanmar. There are some discussions around certain actions contemplated against Myanmar by the Financial Action Task Force, which enunciates 40+9 principles for financial activity across the globe, and is a watchdog whereby they are contemplating whether Myanmar should be under the blacklist of observance. Now, let me just clarify. Blacklist doesn't mean that money cannot go in and get out of the country. It basically means that there will be much stricter compliance and diligence requirement on the banks, which does make the financial activity less efficacious. To circumvent or to overcome the issues which we have generally seen, Myanmar has tried to enter into some direct currency settlements with Thailand at high border trade, for high border trade, and similarly with China and Yuan for China border trade. Next slide, please. Thank you, Wate. Now, let's understand, I wouldn't say just Myanmar, which is facing a dollar crisis. Many countries across the region and globally are facing similar challenges, particularly because of first COVID, and then also to a great extent, Russia and Ukraine war has affected this situation. We would see from surroundings, INR has fell roughly 7% in since the advent of Russia-Ukraine war, and we see similar situation with dollar in places like Laos. Given the general crisis, which obviously has multiplied in context of Myanmar, given Myanmar's political situation, which led to certain measures being implemented by Central Bank of Myanmar. Particularly, Myanmar has brought about certain notifications, and I'm not going to touch upon each notification and what they talk about, but primarily highlight the main crux of what it is. And these notifications would, locally be known as de-dollarization notification. So the first and foremost important notification is that all banks are required to, authorized dealer banks are required to convert the inward remittances of Forex within a day's settlement, save for the remittances for bank account holders which fall under the exempted entities. These entities would be entities which are holding MIC permit and or special economic zone permit, employees of INGOs or international organization, embassies, and so on and so forth. Importantly, there was another notification which was issued, whereby a body was established again to supervise and monitor the financial situation, and particularly forex situation in Myanmar, called FESC, that is Foreign Exchange Supervisory Committee, which basically supervises all inward and outward remittances at present in Myanmar, and thus any monies going out of the country would require a prior approval of FESC, which obviously we understand cannot be directly approached, and the process is routed through the Central Bank of Myanmar. Now, there has been certain, public view around the issues and businesses which had to deal with foreign exchanges, and thus leading to certain exemptions further being granted, first to the logistics sector, whereby certain quotas have been implemented for logistic businesses via air, sea or land, and importantly for exporters who are now allowed to keep up to 35% of their export earnings in USD, and would have to, or any other foreign exchange, and would have to convert 65% of the forex earning into Myanmar Chat. Important to note that there has been liberty granted to the to the exporters to be able to sell their 35% of forexes locally to other residents who are in need of foreign exchanges without having to take central bank's approval in that regard. Basically, there is another angle which has come up, which is pretty much talked about and affects individuals. That is to say that the migrant workers who have been living offshore and working offshore, they have to now basically remitted. I mean, the money which they remit has to be remitted through the authorized dealers, and there are some discussions about their earnings being converted at a more preferential rate, and certain banks have also come out with those notifications. That's all. Jack, over to you from here.
So maybe Diber, you can give a brief overview of the current tax rates and tax systems applicable in Myanmar.
Okay, thank you, Jack and Nishant. So here we provide here a table of the tax rates that were applicable for the current year. So these are the tax rates that are being applied and followed by the Internal Revenue Department or the Tax Authority of Myanmar. So for the corporate income tax rate, the current income tax rate, it's at 22%. It's based on taxable income. The tax rate can be reduced if the company is registered or incorporated under the Yangon Stock Exchange. So the commercial tax is similar to a VAT system, which is an indirect tax imposed on goods, services provided in Myanmar, and manufacturing. So the tax rate is generally at 5%. There are special rates as provided under the Union Tax Law. With respect to withholding tax, currently there's no dividend tax or withholding tax on dividend payments, whether made to resident or non-resident. Meanwhile, for withholding tax on interest payments to non-residents, as well as royalty payments to non-residents, the withholding tax rate is at 15%. The services, it's generally subject to 2.5% withholding tax. The personal income tax or the employee taxes, it's ranging from 0 to 25% based on the taxable income. With respect to capital gains tax, the tax is at 10%, but the tax rate can be higher for companies engaged in the upstream oil and gas exploration sector. For tax treaty network, currently Myanmar has 8 tax treaties. So the countries are Singapore, Thailand, Vietnam, Laos, Malaysia, India, South Korea, and United Kingdom. So currently the application of a tax treaty is subject to approval from the IRD. So it's not automatically granted by the IRD. For transfer pricing rules, currently there is none, but there is already a proposal to under the current draft of the income tax law to introduce the concept of an arm's length and the concept of transfer pricing. So it will just be a matter of time when the official transfer pricing guidelines will have to be implemented in Myanmar. So these are the general taxes that you must be aware as we discuss further in terms of the restructuring options available to a company.
Next slide, please. So I guess as we move into looking at actual business restructuring, and so maybe Nishant, I'll ask you a question based on what you've seen and in Myanmar, in practice, what are the kinds of business restructuring that are happening in practice in Myanmar?
Thank you, Jack. And I think so a pertinent question as to what is the macro landscape which we are seeing in Myanmar. Now, see, I mean, I would categorize this into two broader prongs first, and that is to there are companies which want to basically scale down, but continue to be operational. And then there are restructurings from primarily, a very macro exit and or M&A angle of it, maybe a distressed M&A angle of it. Now, I understand we are not touching in upon a fair bit of operational side of it, but the reality is that tools what we are discussing here are also the tools which can be used with different permutations and combinations for all kinds of business judgment which you and your board has basically taken. Now, to get to the core of your question, Jack, we primarily see if we are going through the operational side. So there's obviously a labor restructuring, which is the most important aspect of it. And then there are certain, loans and or other debts restructuring, which happens and which we'll touch upon. And then again, there are scaling down activities and or exit activities, which we have seen with respect to direct or indirect transfer of shares and or asset sales, and in considerable number, winding up and exits. Yeah. You're on mute, Jack.
Okay, I think next slide, please.
Jack, I think so. We may want to go back to a slide and talk about the direct transfer of shares, right?
Okay, can you go back one slide, please? Okay, so Diber, regarding a direct transfer of shares, can you comment a little bit on, what are the general tax implications of a direct sale, and explain maybe to the people attending what we mean the difference between a direct and an indirect transfer of shares?
Okay, thank you, Jack. So I'll run through first the tax implication of a share transfer, and then Nishant would go on the regulatory side on the implication on this. So for the share transfer, the taxes that would apply on here would be on capital gains tax and stamp duty. So I will just give a brief introduction on capital gains tax and stamp duty. So as I mentioned earlier, capital gains tax, it's at 10% of the capital gain. So a share is considered a capital asset. So in case of a direct transfer, the transfer of the shares would be considered as a sale or a transfer of a capital asset, which is subject to capital gains tax. So it is a tax imposed on the seller, and it is applicable whether the seller is a resident or a non-resident of Myanmar. Now, for stamp duty, for documents that have been executed in Myanmar or required to be executed in Myanmar, in case of share transfer, it would be share transfer documents such as the share transfer form and share purchase agreement. Those types of agreements will be subject to stamp duty. So the main instrument that will be subject to stamp duty, it's the share transfer form, which is 0.1% of the value of the sale. Meanwhile, for share purchase agreement, it will just be considered as an incidental agreement or incidental instrument that will also be subject to a minimal stamp duty maximum of approximately $70. So for tax notification requirement, for share transfer, there is a requirement under the tax administration law to notify the Internal Revenue Department for any changes in the shareholding structure as per the company extract or micro extract as submitted or applied to the DICA or Directorate of Investment and Company Administration. So the notification requirement would be applicable for share transfer, and it must be within 15 days from the time of update with the MICO. In terms of tax relief or protection under the existing DTA, so for direct transfer, it depends on the residency of the seller, and it depends on the types of requirements. In terms of the types of transaction that are being involved for direct transfer. So DTA countries can provide tax exemption or a relief in terms of the application of capital gains tax. But the exemption under the DTA is not automatic. So if you're applying for an exemption, then you must secure an approval from the IRD first before an exemption can be applied. With respect to assumption of tax liability by the new owner, so normally for share transfer, the net asset of the company will have to be transferred. So that means that the acquirer will also assume the liability, the existing liability of the acquired company. So or the previous owner. So in terms of this, the new owner will have to assume all liabilities attached to the shares that are being transferred. So just to give you an overview, the statute of limitation in Myanmar, it's 6 years from the assessment year. Assessment year is considered the year following the income year. So basically, it's IRD can go after 7 years, within 7 years from the time of the financial year ends. So they can go back at the period where the company is still not the owner of the shares, as long as you have you already are in the possession or the shares have already been transferred to you. With regard to the regulatory side of the share transfer, I'll let my colleague Nishant run through the details.
Thank you, Diber. And so from a regulatory perspective, I would first categorize the companies into two broader prongs. First being the companies which do not have investment permits and are generally a DICA-based company, which is the company registry, and are conducting service activities which primarily may not require licenses. For those companies, obviously, share transfer is pretty straightforward. You go ahead and you agree on the terms of transfer of shares, enter into the relevant documentations, factor the tax aspects which Diber just talked about, execute the documents, and then register the transfer on the DICA website, along with having the update of the register of members which the companies are required to maintain internally. And important to note that a transfer is deemed once the member of register with the company is updated, and not when DICA is notified by way of a registry, which is just a notification. Now, let's touch upon the entities which have licenses and or investment permits, and we'll categorize them into two bigger prongs, being MIC or SEZ companies, right? So with respect to certain restrictions, only very few sectors in the latest Myanmar investment law are restricted only for Myanmar nationals, and thus the transfer for such businesses would have to factor that those transfers cannot take place to non-Myanmar, not non-citizen. While most of the other sectors are open for foreigners, some in joint venture and some 100% owned by foreigners. Now, when we are talking about joint ventures for transfers, we have which are regulatory or legally required to be in a joint venture. For transfer, we'll have to factor that joint venture ratio is maintained to say the minimum. Now, with respect to sectorial aspects of it, before you can conduct or compliance aspects of before you can conduct these transfers, the most primary requirement is that you have to get approval from Myanmar Investment Commission in certain cases, and also Thilawa Assisi Committee. There could be restrictions under the license which you're holding. So for instance, if you are a telecom operator, you have to go to PTD and you have to get their sign off. So when you're making an application, you're making an application to both to PTD and to MIC. Now, we have to somewhere keep in mind that while Myanmar has not really issued merger thresholds as yet, merger threshold is a concept whereby under antitrust and or competition, whatever you call it, regimes, you have to go to a regulator, which is in Myanmar called Competition Commission, and seek their approval when the merger leads to certain breach of thresholds. And this is primarily required from maintaining the competition in the country. Now, so the merger threshold has not yet been prescribed by the regulators in Myanmar, save for one sector, which is telecom, where the telecom rules themselves prescribe for merger thresholds. We have seen in past with respect to certain exits where the sectorial regulator asked us to also copy the application to the Competition Commission so that they could verify it and consider whether this would affect competition in Myanmar or not. Another thing which we have to factor when we are looking into share transfer is HR side of it. Primarily, it is imperative that we manage the HR expectations properly. That is to say, at the very initial phases of your discussions on the commercials, you may have to get clarity as to what the expectation of or what's the plan of the buyer from an HR angle, and then you have to probably manage and mitigate the expectation or the issues which may crop up with the plan of the buyer upfront and probably work towards it. Last, most important aspect, many of the companies have these agreements with third parties. You have, I'm going on to the loan agreement separately, but say your service providers, say your off-takers, say your suppliers, and there could be certain limitations on you to be able to transfer without their approval. So a diligence of that has to be taken into consideration. Particularly with respect to debts, if any, loans, you would see most of the loan agreements have fair bit of restrictions on change of ownership. So you might also have to go back to your lender before you can transfer the shares and go back before you can transfer the shares and take their consent to be able to transfer the shares. So these are the requirements which have to be achieved before you can go and transfer the shares, which is the same process as it would be for a simple DICA company. Over to you, Jack.
Next slide, please. Okay, so we've just looked at the concept of a direct transfer, meaning a direct ownership in shares in a Myanmar company. But we've also got the case of dealing with an indirect transfer, meaning that it may not be a direct sale or transfer in shares, it may be done indirectly by a holding company further up in the tiers of holding companies. So in that case, Nishant, can you give what are the regulatory requirements in such a case where it's not a direct shareholding in a Myanmar company, but there's an indirect shareholding or control of a Myanmar entity?
No, good question. In fact, we have seen that a fair bit, because when in Myanmar was going through that investment cycle, given the DTA which Diber talked about, many companies, for instance, had their holding company at Singapore level, primarily as a vehicle for investing into Myanmar. And when they are now transferring, they're simply transferring it at, say, Singapore level, which cuts a lot of local compliances, but not all. So primarily speaking, the regulatory approval would be dependent upon sector. So say if I'm going through a telecom M&A, we have to get even an approval for those offshore transfers from the regulator, as it's embedded in the license of telecom companies itself. Similarly, for all MIC companies, there is the provisions of Rule 191 of the Myanmar Investment Rules clearly enunciate that it's at a parent level also, if there is a transfer that requires an approval. Similarly, in the competition law can have extraterritorial effects if it leads to appreciable effect on competition in Myanmar, and thus in all those cases you also have to go ahead and get approval when regulators do impose this requirement, given the merger threshold is not there, to be able to go ahead and get their blessings as well. So to sum it up, primarily, and also the contractual agreements have similar provisions where it may affect at parent company level, share transfer at parent company level as well. So to sum it up, what you basically cut short is HR aspect of it and local compliances of it. But for most of the sectors, you would still need regulatory approval for transfer at parent company level. Importantly, we have to factor for companies which are primarily Myanmar companies and have invested offshore to reroute it into Myanmar as an investment. You might want to check whether the central bank's approval was in place before you made that investment offshore, because it is a requirement under the foreign exchange management law that central bank's prior approval is necessary for any investments outside Myanmar. So when you are going back to the regulators for those offshore transfers, there could be certain internal discussions between MIC and or SCZ with the central bank, whereby this requirement may be asked of you to evidence that you had procured it. Over to you, Diber. Want to talk about tax a bit on this?
Okay, thank you, Nishant. So with regard to indirect transfer, actually this is a tricky or gray area for tax in Myanmar. So currently there are no clear guidelines and there are no clear rules with regard to indirect transfer of shares in a Myanmar holding company. There is a provision under the income tax rule in Myanmar, which provide that the scope of capital gains tax would cover any other ways of transfer. So that, from that provision, there is a risk that indirect transfer of tax may attract capital gains tax in Myanmar. Now, the question is, in terms of practice, is this being applied? So from what we have seen, indirect transfer, taxes on indirect transfers are not commonly applied by the IRD based on current practice. But we have seen cases where the IRD has applied an indirect transfer as subject to Myanmar tax. So these are cases where it involves oil and gas transfer or transfer of interest in an oil and gas block. So even if the transfer is considered an indirect, they have taxed it as part of a Myanmar source income for tax purposes. But other than oil and gas sector, we have not yet seen a case where indirect transfers are being subjected to Myanmar capital gains tax. So for stamp duty, if it's an offshore instrument and not required to be enforced in Myanmar or to be enforced in a Myanmar court, then the requirement of Myanmar stamp duty will not apply. However, you may have to check in terms of the requirement of stamping with regard to the country of the sale will take place. Now, for notification requirement, it's also not clear under the current provision of the income tax rules. And with regard to tax relief or protection under the DTA, as I've mentioned, the DTA with Myanmar provides an exemption on capital gains tax. So some DTAs have included or covers also indirect tax exempt, indirect transfers to be covered as exempt from tax. But again, for the application of DTA, it's not automatic and it must be approved by the IRD before availing any relief or exemption.
Nishant, can I ask you, how long in practice does it take to complete a share transfer? And what would you say are the key takeaway issues regarding share transfers from a regulatory perspective?
You have hit the nail in the head. I could say it that way. Depends, honestly speaking. It depends upon sector to sector. It depends upon scale of operation. Some sector which we worked on over the period of 2021 till today, one particular case, without highlighting the sector, took us 9 to 10 months to complete the process, and it was an offshore transfer. Like the transfer was happening at the parent level, but I also understand that the sector was very important. And the scale was large. But then again, if you're looking at, say, a DICA company which has lesser operations, it can basically be done within a span of, as soon as you've finalized your documentation, you really don't have any regulatory approval. You've managed your HR angle, you've managed your contractual commitments. You can transfer the company within a span of a week to 2. And then obviously the tax compliances, which Diber talked about, entails and takes a little longer because of the reporting requirements and clearances from there. Importantly, if we are looking at certain sectors such as CMPs, which are small scale but often have MIC, CMP is cut, make and pack, which is the garment industry known as. They are smaller scale investments. They do have MIC permit though, because they need the long-term land right authorization. So those sectors you would see would be fairly quick. I would say a month to 45 to 30 days for regulators to be able to give you their sign off. And I don't think so Competition Commission would be imposed as a requirement on such small scale investments. Now, with respect to issue, as I had a little bit touched upon, foremost issue which you would see in all sorts of transfers is the dilemma which your workforce starts to undergo, given the information when it hits them that company is about to be sold at this level or that level, right? So HR angle is important. Myanmar has robust safeguards for employees, so you have to factor those, and you have to factor that you are not missing out on regulatory approvals where necessary. And importantly, do diligence your contracts. There could be a situation which could lead to claims against you because you have not factored in diligence your contracts, which may require a prior approval.
Okay. So Diber, before we move on away from share transfers and we look at asset arrangements and asset transfers, what would you say would be the key takeaway common issues that companies need to consider when looking at share transfers in Myanmar?
So for the common tax issues for share transfer, this would basically on how to determine the consideration for the sale, because there are no clear guidelines under the current tax rules on how to value a consideration. Um, but uh, but if it's a related party transaction, please note that the current provision of the income tax rules uh, gives the power for the IRD to make or to adjust the price if they consider that the price is not made or does not commensurate to the value of the sale. So they can check reasonable basis or comparable that they can find adequate to justify how much is the value of the sale. So from the current practice, they normally follow the price that has been mentioned in the share transfer form. Um, and that price will be used as basis in determining the capital gain. So uh, for capital gains, it's the sale, and then there is a deduction on the cost. So for determining the cost of the shares, it's basically the amount of the acquisition cost of the shares as supported by the current provision on the MICO extract. So again, for tax, you need to take care of or consider how much will be the value of the sale and whether it is considered as reasonable, consider, especially if it's a related party transaction. Second, in terms of determining the capital gain, that the capital gain will be based on the selling price or the fair market value of the shares, less the cost of acquisition of the shares. There are some deductions under the income tax rule on the allowable deductions, but this may be subject to confirmation from the tax office, depending on whether it's relevant on the share transfer or not.
Thank you, Diber. Can we move to next slide, please? Okay, so regarding asset transfers, in practice, what do you see, Nishant?
Asset transfer at present is there, but at a little lesser scale. It's more as a tool to scale down and or get out of distress to be able to part a bit of asset and continue to be in operation. But there is obviously a plus side, and Diber did touch upon it from a tax angle. When we talk about share transfer, you inherit the books of the company, which has its assets and which has its liabilities. Now, when we are talking about asset transfer, we are only looking at the assets, and liability remains obviously of the seller company. But with the asset transfer, if you as the entity which is restructuring is looking at an asset transfer, please understand that you would still have to follow the entailing compliance, that is the dissolution of the existing company if you have zeroed down on the assets. Primarily from a regulatory perspective, whether it's a share transfer or it's an asset transfer, if you are breaching the thresholds as prescribed in, say, Myanmar investment law and or SEZ, Special Economic Zone law, and in fact in Tilava Economic Zone law, there are certain further undertakings which are not part of the law, which you as a company provide to the management committee while getting the permit. If those conditions are breached, then you have to factor a prior approval before you can also sell the assets. In most cases, it is 50% and above of the company. We have to factor that there could be assets which are integral to, say, a very important sector for the country, and there could be the licenses which may have conditions where you need prior approval. Importantly, you might have debts where you have mortgaged and or pledged, hypothecated your assets, and thus you will need prior approval from your lenders to be able to release that first before you can make those sales. We have to be mindful of the marketability of the asset at present, particularly if you're looking at a cross-border sale. if you would understand, the regulatory approval is a bit slow, particularly from being able to export it. It's not disallowed, but it is important to note that you might be slowing down and having held for a long time in the warehouse at the port before you can basically ship that. And I believe there are some tax implications on it, which Diber will talk about. So these are some primary, bigger picture aspects of asset transfer. Jack, Diber, over to you.
Okay, thank you, Nishant. So from a tax perspective, in terms of asset transfer, the major consideration here would be on the valuation. So especially if you're transferring immovable properties such as land, or transferring building or vehicles, this will be subject to an assessment by the IRD. So a separate valuation assessment will have to be conducted before you can actually transfer or sell the immovable properties. So even if you have indicated an amount in the selling in the sale purchase agreement, they will still have to revalue it, and then from their valuation, that will be their basis on how to calculate your taxes on the asset transfer. So with regard to the other types of taxes, so it would depend on the types of assets to be transferred. So if the assets to be transferred would include inventories or specific goods, then the taxes on commercial tax as well as specific goods tax can also apply. There are also property taxes applicable on this when you assume the property, but this property taxes mainly on the immovable properties. For stamp duty, if you are transferring movable properties, then it will be subject to 2% stamp duty. If the transfer would involve immovable properties, then there is an additional stamp duty of 2%. So the stamp duty for immovable properties would go as high as 4%. In some cases, 6% depending on the place or the location of the property. For MIC or SEC companies, if you intend to have it sold, the assets that have been acquired and which were initially exempted from customs duties or taxes on importation, once you resell those assets, you will have to repay the taxes that were initially exempted at the time of importation. An exemption on that is if it will be used as a continuity by a new investment, which is also registered by a company registered, for example, with the MIC. And in terms of tax relief, again, it would depend on the application of the DTA, and the assumption of the liability, it's on the new owner. So for asset transfer, if it involves immovable property, then you will have to assume also the obligations or taxes in relation to the property transferred.
Okay, thank you, Diber. Should we have a look at loan restructuring and the implications around this? Maybe Nishant, you can give a quick overview.
Sure. So, Jack, I mean, we have seen this quite often these days, especially since the notification bringing about that temporary suspension on repayment for offshore loans, and where the authorized dealers are directed to require their clients to discuss with their respective offshore lenders to reschedule their to discuss readjustment of the repayment schedule. Now, primarily speaking, you need a CBM approval as the first thing because the repayment schedule is changing. You might have to go ahead and enter into the documentation side of it, whereby what we have seen generally in most of the sectors, particularly MFI sector, where people are on a standstill. Let's see when they will be able to, Myanmar will be able to allow these remittances, but also many DFIs have taken a huge haircut of their exposures in Myanmar as far as loan restructuring is concerned. So by all aspects, you would require a Central Bank of Myanmar's approval. If it is affecting your debt to equity ratio, which you may have submitted with the Myanmar Investment Commission while you were getting your approvals, then you may have to go to Myanmar Investment Commission and report it as a change. You don't need an approval, but you would need a reporting requirement as a part of your quarterly update and or annual update. On the timeline, it depends again on the size of the loan and other variables which are better understood by the regulators. But we have seen generally this can take somewhere between 60 days to 6 months.
Okay, so you mentioned the debt to equity ratio. So maybe to Diber, given that Nishant mentioned the debt to equity ratio, are there any specific thin capitalization rules regarding taxation in Myanmar?
Currently, Jack, for thin capitalization, there is no thin capitalization rule, but the IRD follows the debt to equity ratio for MIC companies and non-MIC companies as provided by the CBM. So for MIC companies, it's 4:1 debt to equity, while for non-MIC, it's 3:1.
What about the tax implications of loan forgiveness in Myanmar? What would happen in such a case?
So in terms of loan forgiveness, currently there is no clarity on the tax aspect for loan forgiveness, but in general, and from what we have seen in practice to be conducted by the IRD, they consider loan forgiveness as a form of taxable income from the point of the borrower. So they will be subject, or this is considered part of the taxable income that is subject to regular corporate income tax. Now, with respect to other types of loan restructuring, for the amendment of loan terms, what you need to consider here is on the stamping of the agreements, depending on what type of agreements will you have to execute. And at the same time, if there is interest component or interest payment in relation to the restructuring, then the interest payment will be subject to 15% withholding tax if it's made to a non-resident. This also applies in cases of offsetting of loan repayment. So instead of a direct payment, it will just be offset to an existing liability to the same lender. Then it will also be considered as a constructive payment of interest. And that would also be subject to 15% withholding tax, even if there is no direct withholding tax. I mean, even if there's no direct payment to the lender. So conversion of shareholder loan. So generally, conversion itself will not trigger tax. But if there are any agreements to be executed in relation to the loan conversion, then the stamping part of the transaction must also be considered.
And Diber, in practice, does the IRD apply any form of arm's length principle or arm's length rule to related party loans?
Currently, for related party loans, we have not yet seen that the IRD has strictly applied the arm's length principle. But from what we have understand and from our previous experience, they normally would check whether it is considered. If there is an interest component of the loan, then they will check if it's considered reasonable. But again, in practice, shareholder loans can be provided on without interest based on current rules, but we never know once the new income tax law will be implemented if they will have to also consider and factor in the charging of interest.
Okay, interesting. Next slide, please. Okay, so if there's companies that are moving towards the stage of looking at a winding up or liquidation in Myanmar, deregistration of the company, Nishant, can you describe that process? You're on mute, Nishant.
Sure, Jack. I mean, we understand it also depends upon scale of the company and whether it's a company or it's a overseas corporation registered in Myanmar. So primary process is before you hit the liquidation stage, you have to do your preparatory work. The first part is if you are an MIC holding company, permit holding, or Tilawai CZ permit holding and have certain licenses, you have to go ahead and you have to start the process of surrendering the licenses and or taking regulatory approval from MIC, SCZ. You have to at the same time factor the diligence side of it with respect to your liabilities, satisfaction of any claims, dealing with employments and payment of severances, etc. Important to note here, if you have 30 employees and above in your company, you must have established a workmen coordination committee, which is comprising of 2 representatives of employees and 2 representatives of employers. And thus any redundancy related terminations have to be in consultation with a workforce coordination committee. So if you have not, please start looking into this requirement and start establishing it. And then yes, once you have able to clear your books as far as possible, and you have able to dispose of your assets, sell them, then you go ahead and you enter the liquidation stage. At the liquidation stage, the first and primary requirement is that an insolvent company cannot be voluntarily wound up. So an insolvent company has to factor it through the insolvency route, where there is a rescue, rehabilitation, and or winding up mechanism through the courts. In a wallet, and we are touching upon only voluntary winding up here. The first step would be to pass director's resolution to subject the company into voluntary winding up and issue a solvency statement. That means all the directors issue a solvency statement along with the resolution that the company should be wound up. Within the passing of that solvency statement and the director's resolution, within 21 days, the members of the company have to resolve that yes, the company should be wound up. When I say members, they are shareholders of the company. The moment the resolution is passed, the company is in liquidation. Once the company is in liquidation, liquidator is appointed in the same meeting. Now the process after this part is taken over by the liquidator who's appointed. You may have to employ 1 or 2 persons to be able to assist the liquidator with the information and other records which he want to see for the purpose of liquidating. But the decisions and every operation of the company is then taken over by the liquidator. Difficulty level depends upon the kind of company and the relationship with regulators, etc. We have seen pretty large operations being wound up in period of 6 months and some even 2 years. With respect to overseas corporation, primarily there are ambiguities and there are basically no liquidation process per se. All you need to do is, get it deregistered with DICA. It takes roughly 60 days after filing Form E9 with DICA, and the company is removed from the company. And then obviously there are tax side of it, which I will defer to Diber to speak about.
Okay, thank you, Nishant. So for voluntary liquidation and deregistration, both scenarios would require to secure a tax clearance. So a tax clearance from the IRD would have to be required to be secured before completing the liquidation procedure. Now, for tax clearance, the tax office can go back to the past 7 years, which is the statute of limitation under the tax administration law. So you need to check whether the company has an existing tax assessment confirmation from the IRD, because the IRD would go back to the last year where the tax assessment confirmation has been secured. But in any case, in terms of liquidation, they can still go back to as late as 7 years prior to the close of the business. Now, for liquidation, the tax administration law also provides that the IRD can go after to the shareholder, and if it's related to a transaction that happened when the shareholder was not yet present, they can still go after to the original seller when when the transaction that has an existing liability arose. So as to how it will be implemented by the IRD, it's not yet clear. But this is also part of the liquidation procedure that needs to be accounted for when you consider for this voluntary liquidation. So this is one part of the liquidation aspect that would normally take longer time, because this is subject to the review and assessment of the IRD.
Thank you, Diber. And next slide, please. Okay, so finally, regarding planning for restructuring, and when we talk about the legal and tax aspects, Nishant, what are the key considerations in Myanmar when considering to restructure a company or business?
Sorry, I think so. If we are looking at an exit idea of restructuring, then yes, the most imperative part of this, both from efficacy on exit, but also reputational side of it, becomes the HR angle. So you really need to factor your HR obligations diligently and be able to, be able to address them promptly, but also factor the contractual obligations, or as far as exits are concerned. You have to see and diligence all your different contracts and see what are the conditions for you to exit and or restructure. Similarly, with respect to approvals, you may have to factor CBM approval for certain debt-related restructurings, MIC and regulatory approvals if you're an MIC company, similarly SCZ and regulatory approvals when you're an SCZ company. Then you have to probably factor what are you looking at from a restructuring perspective, whether it's a debt restructuring or it's a asset sale or it's a share transfer. You have to factor into the documentation side of it, and to be able to do that, you have to diligence your 360 before you're able to enter into documentation. Diber, over to you.
Okay, thank you, Nishant. So from a tax angle, when planning to restructure your business, you need to consider what are the taxes that will apply to the proposed transaction, whether it's a share deal, an asset deal, a loan restructuring, or proposed liquidation or exit. We also need to assess the available tax attributes. So tax attributes mean these are the tax assets of the company, such as existing losses, excess tax payments. So you need to factor it in. For example, if you plan to have to condone a debt. So you need to consider if it's subject to corporate income tax of 22%, you need to factor in if you have an excess losses, an excess tax credit that you can maximize or at least use to reduce your existing tax liability. You also need to consider your exit tax consideration. This covers capital gains tax, payment of dividends, which is currently exempt from withholding tax, interest payment, as well as the royalty or service fees. So another thing is on the assessment of tax relief, which is basically provided under the DTA. So you may have to check whether the transaction would qualify as a transaction that can be covered by a relief or an exemption under an existing DTA. And lastly, you need to factor in also any tax liability that you will have to assume when you are considering asset deal or share deal transaction.
Okay, thank you, Diber. So we got some questions, so maybe we have a little bit of time and we can try and answer some of these questions. So the first one's to Nishant. A question has come in to say, in an asset sale structure, have you seen assets being exported out of Myanmar?
Good question. Yes, we have. In fact, Diber was part of the same team advising on tax applications of re-export of machines. And I will defer to Diber on situations where it's an MIC company and it was brought into the country by way of under tax exemptions for importation purposes. Yes, the primary requirement is that you have to get Ministry of Commerce's approval, and this follows subsequent to, say, your MIC and regulatory approvals to be able to sell your assets where applicable. Once the MOC approval is in place, the custom department basically obligates and ships the assets out of the country. One important aspect of it is that before MOC will approve and or between MOC approval till the custom clearances, you'll have to ensure that the monies have been brought into the country and or there are specific exemptions by way of an offset or some other mechanism whereby regulators are comfortable that the money may not come on shore.
Anything to add, Diber?
For that transaction, Nishant, there must be a notice to the IRD with regard to the sale of the assets. Assets to be exported. So in addition, you need also to consider the taxes. As mentioned, you will have to repay the taxes on the that were initially exempted upon importation of the goods. So that includes 5% commercial tax on importation, the customs duties, and any advanced income tax if they have. But in practice, it's not being considered, the advanced income tax. Now, in addition to that, you also need to consider or factor in capital gains tax, which you will have to be subject for the sale, and any stamp duty on the agreements to be executed.
Okay. So I think, Diber, the next question is for you. You mentioned around getting potentially relief and exemptions under double tax agreements that Myanmar has signed with Singapore, Thailand, UK, etc. So how long does that process take in practice?
Yes, in terms of application of a DTA, there is no clear procedures by the IRD on how to apply for a DTA. There is an announcement before with respect to requirement of securing certificate of residency by the non-resident, but as to the process on how they handle exemption or relief if invoking a tax treaty provision, it remains unclear. So from our experience, we have seen cases where it could go up to maybe 6 months or more. But again, it depends on the types of transaction and it depends on the appreciation of facts. So it's not automatically applied, the relief and exemption. So you need to get an approval first before applying any relief.
Okay, thank you, Diber. I think question for you, Nishant. The question is, given the current embargo on offshore loan repayments, what workarounds can lenders think of?
Yes, it's a dilemma, and basically what we have seen is while you can still try and go back to FESC and try to make out a case that why your loan should still be permitted despite that embargo. But that's one aspect of it. If that doesn't come by, you have to think it from a borrower's perspective, because you don't want to accelerate and call the default, because then you have marketability issue with the assets if you're going to enforce as a lender. So even if you enforce, there's nobody who may be that much willing to buy, or if somebody's buying, there is always a distress angle attached to it. So what as a mechanism one can consider is under the loan agreements, the default would only arise once the lender has not repaid. Now, if the borrower has not repaid, but now if the lender is willing to open an onshore bank account and be able to get the money into that bank account, that is one example. But the problem there is that once there's no clarity whether non-residents' bank account would also be compulsorily converted into, say, local chat. In that case, the lenders can also consider whereby an escrow arrangement is created, where the bank itself is considered to be an escrow agent, and the monies are kept with the bank in their sundry or other forms of account, which need not necessarily be converted into MMK. And an escrow agreement is entered between the borrower, lender, and the escrow agent, whereby the trigger would be the day the remittances are allowed. The escrow agent will transfer the money offshore, and in that case, there is no default on one side, and also lenders have a fair bit of safeguard as far as their debt's concerned.
Thank you, Nishant. A question for you, Diber. The question is, in the event of a late filing or late payment of a tax, what are the penalties for taxpayers?
Okay, thanks, Jack. So, in general, the penalty for the late filing and payment of tax is 10% of the tax due. Now, there is a different penalty regime for stamping. For late payment of stamping, it's 3 times of the stamp duty amount. With regard to the filing of the return, if the transaction would require a filing, for example, of an income tax return or a capital gains tax return, then the penalty would be 5% for I mean minimum of 1 lakh, or just roughly around 50 or $50 to $60, up to 5% of the tax due.
Sorry, Diber, on that note, there's one more tax question here. Regarding a tax amnesty, is there any information or regarding potentially a tax amnesty being given by the IRD to taxpayers?
Yes, currently we are not aware of any tax amnesty that that is introduced. So currently, they have extended the tax amnesty for undisclosed sources of income, but that only applies to Myanmar citizens. And so the current regime reduces the income tax rate of the corporate income tax. Previously, it was 25. Now it's 22%. We have not aware of any proposed amnesty procedure, but there is a proposal of a draft of a new income tax law, but that remains unclear when it will be enacted or enforced into law.
Okay, thank you, Diber. I think the final question is to you, Nishant. Is the question says merger thresholds, as you mentioned, are not currently published. Do you think that the Competition Commission has some role in asset or share sales?
I mean, I did touch upon during my discussion regarding both asset sale and share transfer. I totally understand that the merger thresholds are not published, say for one particular sector, that is telecom, under the telecom rules. We have seen in certain situations where the regulator have asked us to also copy the application to the Competition Commission. Let's understand, though the merger thresholds are not published, Competition Commission established. So the body is constituted. So we did file that application. In fact, we were just shy of filing a SNP test, which is a requirement of how the market, it's basically one of the most expanded market understanding of the merger, where our colleagues we did that in-house. Our colleagues based for antitrust practice was able to draft that for us. And it was just short of SNP test. So it was very robust reporting requirements, which was expected of us in that case. But that was only one particular transactions. In others, we just have simply copied Competition Commission without having to have that very enlarged report and economic, financial and economic consideration of the merger.
Okay, thank you, Nishant. I'm conscious of the time, so what I would say is, if you've got more questions, because there's quite a few of them coming through, you can contact Nishant or Diber directly with any questions you may have. They'll be more than happy to have either a call with you, or you can submit an email or contact them directly. And if there's anything that wasn't clear this morning, or you want a copy of the presentation, please, you can either email us directly, or there's a QR code that you can scan and you will receive a copy of the presentation. And as always, if there's any particular topics you'd like to see covered in future webinars through DFDL, please do let us know, and we're always happy to accommodate and any interesting topics that is currently happening in the region. So I'd like to thank my colleagues for taking the time out this morning. Thank you, Nishant, and thank you, Diber. And I'd like to wish everyone a good day ahead, and please stay in touch. Thank you.
Thank you, Jack. Thank you for moderating this so efficaciously.
Thanks. Bye-bye.
Thank you.